Hi, and welcome to another product knowledge video. Today we're going to be talking about errors and omissions for real estate professionals. Our presenter today is a man with the name of John Tarvey. Show you his picture here. He is the Herbert Landy Insurance Agency. It's a general agency, wholesaler, etc. And he's the Vice President of Marketing and Sales, and he's agreed to explain what errors and omissions insurance for real estate professionals is all about. Landy is a general agency, and they have our national program administrators for real estate agents and brokers, errors and omissions insurance, as well as other professional insurance programs, but he's an expert in this, and he's agreed to explain it to us all. So, John, you can tell us why is the E&O insurance important for real estate firms anyway?
Well, George, thank you for having us, and very happy to be here. We know that real estate agents and brokers are very much a part of the family life and commercial life and business success, especially with residential insurance, residential real estate sales. It really is an emotional purchase and very much a part of a family's growth and dreams and hopes. And therefore, we see that both in society and certainly in legal and ethical standards that real estate agents are held to the highest standard. When a family especially is looking to purchase a home of their dreams, they expect the real estate agent to guide them successfully through all the facets of the transaction.
All right, well, let's see what a risk management tool, and that's an important word too.
Well, you know, errors and omissions insurance is all about risk management. The first portion of any type of professional insurance program should be how does a professional manage their business and keep themselves out of trouble in the first place. An E&O policy provides a lot of information about what's covered, what's not covered, how things are covered, who's covered, and it can be very much a roadmap to help a business establish a successful practice and to avoid malpractice claims.
Right. Well, let's. I know it's a lot of ground that they can cover, that real estate practices can cover, because all of us have dealt with real estate people all over our lives. Okay, who's covered? What's exactly covered in errors and omissions?
While all policies are different, in general, real estate agents and brokers E&O policy is going to cover the agents and brokers. It may cover real estate appraisers. It might cover consultants, property managers, auctioneers, short-term escrow services, which can be really important, especially in certain states, and notary services performed on behalf of the client. It's important for any type of real estate firm to really understand who and what is covered, because if they're doing a professional service that's not clearly defined as a covered service in the policy, then of course they're at risk.
All right, let's talk about what's covered then.
Well, yeah, same type of thing, George. You know, what is covered in general, the professional services performed on behalf of a client while acting on behalf of another for a fee or commission and compensation. Again, residential or commercial should be clearly defined in the policy to make sure both of those things are covered for buyers and sellers, brokers and agents, a transactional broker or an agent, an appraiser of real estate consultant, auctioneer, and a counselor or a property manager. Some policies are going to automatically cover these things. Some may need to bring them in by endorsement. Some policies may not cover them at all.
Oh, I see. So what are the most important features then to be aware of in an errors and omissions policy?
Well, we want to talk about who is an insured. It seems like a simple thing, but you want to look for key phrases like current or former partner, employee, and so on, because we want to make sure that the firm is covered for professional services performed by someone who may no longer be a part of the firm, for example? What about the predecessor firms or successor firms? Franchises, if a real estate firm is part of a large national franchise, typically the franchise wants some vicarious coverage under the agent's E&O policy. What about spouses and domestic partners if the named insured or one of the insureds were to become incapacitated or pass away? How is their estate and their family protected still under the E&O policy? And always while acting on behalf of the named insured.
You know what I'm finding out is as you go forward here, I'm finding out that there's a lot of complications in this thing. It's just not as easy as it looks. Just saying errors and omissions insurance. Wow.
Yeah, well, here's an example, George, briefly. Real estate firms typically are staffed by independent contractors. Most agents are independent contractors. We want to make sure that the E&O policy specifically covers the professional services performed by an independent contractor, not just by an employee. Very important that those independent contractors are listed, not by name necessarily, but by the category of independent contractor in the policy.
Right. One more thing that says, yes, this is not simple. But keep going. I'm understanding and I'm learning.
Yeah. Well, you know, one of the things, and I think this is important for a lot of the retail agents who might be listening, is that E&O insurance in general is a very complicated type of product.
It is.
And it's important to understand all of the provisions that are out there. For example, let's start with a simple one, a claim. Everybody knows what a claim is. We know that a claim is an actual demand for money, typically preceded by a subpoena or request. And it's made on an allegation of an error or omission. It includes professional services, but it could also include fair housing and discrimination issues, mold and fungi, disclosure issues, and so many other things. And we also know that a lot of times actions taken against a real estate professional haven't yet become a claim, but they may be something like a license or a disciplinary board hearing or a subpoena expense. And it's important to note in the supplemental payments section of a policy if in fact there's any coverage and under what conditions. For example, if a realtor is brought before a licensing board, we suggest that if there's coverage in the policy that the professional brings an attorney or has an attorney respond to the subpoena or to the board complaint rather than respond on their own.
The more I hear you talk, the more I understand the importance of understanding an errors and omissions insurance policy for real estate people. Wow.
Well, here's where it gets complicated, Judge. I'm sorry. Did you want to?
No. That's it. I thought it was already complicated, but now you're getting more.
No. It wasn't. It's going to get more complicated to some degree. An E&O policy is a claims-made policy. That means that the policy responds when the claim is made, not when the professional service was provided. For example, we know that if a real estate transaction occurs today, the real estate professional is not going to get sued today. They may get sued 3 or 4 or 5 years down the road. So the policy responds when the claim is made, and it has to be within the prior act's or retroactive date of coverage. And that's the date back to typically when the initial policy was purchased or an initial policy was purchased, and coverage has continued through the present time. So if I bought my first policy when I opened my business, for example, back on January 1st, 2010, my prior act date would be January 1st, 2010, and I am covered for all of my professional services since that point, even if I get sued today in August of 2016.
Wow.
The prior acts and retroactive date of coverage may be the most important feature of any type of professional liability or E&O policy. And of course, changing carrier should not change the prior acts date. Unfortunately, sometimes professionals and even insurance agents are given bad advice that if the client changes carriers, they'll lose their prior act date, but that's of course not true.
Okay, I hear you.
Okay. A couple of other things I'll mention if you don't mind. All policies have exclusions. We want to see what's not covered. Again, if a business is performing services that fall under the exclusion category, then they either need to get additional coverage or a new policy, or maybe even stop doing those things. And some typical things you'll see in a real estate E&O policy under the exclusion sections are disputes about fees or commissions, a dispute between an agent and broker over a commission, for an example, intentional wrongdoing or fraud. This is a big one, bodily injury or property damage. So if an agent is doing a showing and someone slips and falls on the property and gets hurt, there probably is not coverage for that under an E&O policy. Sometimes there is, sometimes there's not. Owned real estate, in other words, if an agent is selling their own property, they may or may not have coverage under the E&O policy, or they may have limited coverage. Guaranteed sales listings, of course, are never covered. Pollutants and insured versus insured and so on. So exclusions are really important. And we know that at some point a business may close, a business owner may retire, or other factors lead to the end of the business, so to speak. So an extended reporting period allows the business, or the named insured, to purchase coverage to protect their prior acts date. So again, if my prior acts date is January 1st, 2010, and I want to retire, I still have a legal liability to all of my professional services that I've performed in the past. So an extended reporting period, sometimes called a tail coverage, will allow me to protect my previous professional services.
Good.
And of course, then we have limits of liability. One of the things to look at is defense cost inside the limits, where the cost of defending the claim comes out of that limit and therefore diminishes what's available to actually pay the claim to the plaintiff. Defense cost outside the limit means that whatever it costs the insurance company to defend the client does not diminish the actual limit of liability. So those can be important things to look at for any type of policy holder.
Wow. There's a lot. Keep going.
Oh, yeah, there's a lot. Well, deductibles can be loss only, a loss and expense. A loss only deductible means that the client is only responsible to pay the deductible if they're actually found liable in the suit, whereas a loss and expense deductible means that the deductible comes in from the first dollar and is applied to the expense of the claim as well as the actual loss. A duty to report a claim is important because some policies stipulate that a claim must be reported within a policy period. Some say within 60 days. Some say as soon as reasonably possible. Why this could be important is today is August 10th, 2016. If I receive notice of a claim today and my policy renews tomorrow, August 11th, and I don't report that claim within the policy period and the policy requires that, technically I could be denied coverage. Now, hopefully most insurance companies are not that brutal when it comes to servicing their policies, but it's important to understand how a claim needs to be reported. One of the very cool things that some policies offer is choice of counsel, which means that the insured may have a say or can suggest who they want their legal representation to be in the event of a claim. And of course the insurance company has to approve that, but you know, that may be important, especially for larger firms where they may have an attorney on retainer, they may have a risk management counsel already in place, and if they have a lawsuit, they may want their counsel to represent them. So the other advantage of that is that choice of counsel may mean that if we have a client in California, Northern California, for example, and that client is sued, they can choose and will assign an attorney, a defense attorney from Northern California who's familiar with the jurisdiction, the plaintiff attorney's previous case law, you know, so on and so forth, as opposed to sending somebody out from the home office in Philadelphia or New York City, for example. So having a local or regional attorney to represent a client can be very important as well.
I can see why it would. Well, you know, you've been around a long time and seen a lot of claims. Well, thanks. Yeah, you're welcome. I didn't do it for you. You did it for you. But what kind of claims? What do you see? What have you seen over these years, and what's important?
Well, Yeah. Well, the great majority of claims, and I think even this number, 50 to 75%, might be conservative, involve failure to disclose certain characteristics about a property. And what that means is that the agent may or may not have known that the roof leaks, or that there's mold in the basement, or that there's a problem with an old cesspool on the property, or there's a title issue there, or there's a unpermitted improvement. You know, so many things that an agent or broker needs to know about a property. They may or may not know that the seller may not disclose all of the information about the property. Sometimes even the listing agent might not disclose everything about the property, but it's still the agent's responsibility under the eyes of the law, and certainly the eyes of the public, that they need to know everything about the property and tell the clients, especially the prospective buyer, everything that they know or should know about the clients, about the property rather. We see claims that an agent misrepresented a school system, or the quality of a school system, or again, sometimes it's intentional, sometimes it's not. But the plaintiff lawyer is going to argue, and typically will win, that the agent or broker should have known about a material defect or a property condition, something about the neighborhood and the community. Another situation that a lot of agents run into in terms of their marketing and advertising is that they overstate their credentials, or the credentials of a property. You know, anytime you say the best, this is the best, or this is the most, or I'm an expert in residential sales, or, you know, I'm an expert in this community. You know, whatever those are, you can't prove those things. There's no certification. There's no badge you can put on your chest that says I'm the best, or this is the best school system. So we really encourage in our risk management programs for agents and brokers not to use superlatives that they can't quantify or justify.
That's a great point.
But those are the kind of things that people that get agents in trouble. Some more specific examples, again, misrepresentation could be seen as disclosure around zoning, square footage issues, condition. Property managers get in trouble a lot with fair housing indiscrimination, improper evictions, you know, those types of things. Leasing issues get property managers into trouble a lot. You know, we really recommend that they leave evictions, especially to the lawyers and to the police, and not take those matters into their own hands. Escrow services and money disputes are very, very common that we see. Failure to maintain the property for property managers, again. Breach of contract and alleged negligence are broad legal terms, but those are terms that the plaintiff attorney will use and file suit against the real estate agent in an attempt to win their case. A breach of contract could be that the agent failed to, again, provide certain information about the property, didn't handle the paperwork properly, didn't meet time deadlines. They said they were going to have 3 open houses and only had 2. Again, these are things that get agents and brokers into trouble, and typically those are the kind of E&O claims that we see.
All right, how do we keep agents out of trouble? What do they do? How do you avoid these things?
Well, the first thing is to disclose. Disclose. Everything needs to disclose all the facts that may affect the desirability or the value of a property, and not to overstate it, but when in doubt, disclose. An agent or a broker can never lose by telling their client about the information. If the client wants the house, even if there's a defect, they can renegotiate the price, they can negotiate a repair, they can walk away from the deal, but there's other deals to be made out there. Walking away from a deal is a lot better than getting sued.
I'll bet. Go ahead.
Yeah, well, some other things that you know, a real estate firm may want to consider in terms of coverage would be a business owner policy or a commercial general liability policy. A business owner policy, or a BOP, is basically a commercial general liability policy which protects the policyholder from a slip and fall or property damage claim, again, which could be really important for an open house or a showing where somebody might slip on the property or damage done to the property during a showing. The business owner package extends the slip and fall property damage coverage to actually providing protection for the real estate firm's business equipment, signs, advertising equipment, data protection, and so on. And most real estate firms, most businesses in general that are renting office space are typically required to carry this coverage. Workers' compensation, of course, is required in most states for any business that has W-2 employees. Workers' compensation is not required for independent contractors except in California. California realtors, real estate agents and brokers are strongly suggested to carry workers' compensation for independent contractors, but we've seen in real life that it's really a mandate. But that's the only state where independent contractors have to be covered under workers' compensation. Privacy breach and cybercrime is probably the hottest issue right now, George. We know every day we're hearing stories about what's being hacked and whose identity is being stolen, what information is being stolen. And that's really now become a bigger issue for real estate firms where you get into the cybercrime issue, which is really stealing money, wire fraud, misrepresentation, where escrow funds and other trust funds are being stolen through misrepresentation and other types of fraud by the bad guys. We have heard and seen about escrow monies as much as $2 million being fraudulently accessed by the bad guy. It's a complicated subject, maybe needs a whole other webinar in that sense, but any real estate firm that is escrowing client funds, whether in anticipation of a sale or is holding deposits and the damage deposits and so on for property management, really needs to take a close look at purchasing privacy breach and cybercrime insurance.
Oh, it is just wild today. I mean, I agree with you. It's the number one concern. Okay, as we wind down now, let's give some tips about avoiding claims.
Okay. Yeah, there's a lot here, and I hope all of the listeners will take advantage of taking a better look at this slideshow. But communicating with the client is so important, and that includes telling them, again, everything that you know or should need to know. And if you don't know something, then tell the client you don't know and let them know that, A, you either can't give that advice, for example, legal advice or tax advice, or you'll try to find out. And the next step is that you document everything. We do so much by claims, or by text rather, and email and so on. Everything needs to be documented, and we suggest that a real estate professional doesn't engage in important dialogue through text, for example. Anything should be an email or in some written form that can be stored and maintained and shown to the court and to the attorneys should the agent get sued. Watch out about privacy issues, especially with social media. If you're posting information about a property on social media, make sure that you're not invading anybody's privacy, like the neighbors, for example, when you are disclosing that information. Don't exaggerate. Clarify what's fact and what is opinion, and again, document everything. Never predict the future. There's a lot here, George.
Oh, I know.
You know, we can spend a lot of time with this, and if we haven't made the point, disclose, disclose, disclose.
Well, I think that seems to be the point. That's what I hear coming through. Don't hold back. I mean, I guess it's not much they can do after they tell everything they know, and they're. I guess we're talking about honesty, aren't we? All the way down to the bottom of it.
And we're talking about documenting that as well.
Yeah. Maybe it's not just honesty. Maybe it's not knowing. And I think that what you're saying here is really amazing. John, you've talked about before to me a seller's disclosure statement. Tell us about that.
Yes. Well, typically it's required under state law that a seller disclose information about the property condition or any known features of the property, and in some states that could even include, things that have happened on the property that, if it was a former drug lab or somebody died on the property. So it can get pretty crazy in that sense. But the seller's disclosure statement should list everything that the seller knows about the property. Now, in real life, we know that sometimes they try to hide that stuff because they want to make the sale. And the agent should be inquisitive to really look around the property and see that the seller's disclosure form is accurate. And if they see something that is not on the form, or even if it's not required to be on the form, that they disclose that anyway. Community conditions, neighbor conditions, neighborhood conditions, school issues, whatever it is. Again, the more that the agent tells the potential buyer, the less likely that they're going to get sued. We have to get past the point that we have to make the sale. One of the biggest points in risk management, I think, is to choose your clients wisely. Everybody doesn't need everybody as a client. And when you have a good client, treat them fairly, treat them honestly, let them know everything that you can possibly find out about the property to help them and to avoid a lawsuit on behalf of the real estate agent.
That's good. Any last words here now before we hang up here? What about?
No.
Well, you don't.
No, go right ahead.
You always said don't act outside your area of expertise. I know that. That's Let's go to
very
that.
True.
There.
For example, someone who is familiar with a certain community, a geographic area, should stay in that area. If they are asked to take a listing or assist a buyer in an area outside of their geographic competency, that's something that they should consider whether or not they want to do, or should make a referral to a different agent. If they're traditionally a residential seller or buyer's agent, and they're asked to take on a commercial listing or represent a commercial buyer, again, they should really consider whether or not they are capable of doing that. We mentioned property management earlier. Property managers do get in trouble by acting outside of the areas of expertise sometimes when they get into fair housing issues, eviction issues, those types of things. So again, a great risk management tool is to make sure that you act within your areas of competency, and if you want to expand that, that's great. We all want to grow as professionals, but take the classes, get the information, learn how to do it first before you jump in.
Thank you, John. You did a wonderful outline here, and I can see the complexities of this. The more I see, the more I realize how important it is when the listener goes to back to the agency whose website this is on and talks to him or her. They're going to understand a lot more about it. They can always just go back in here and look at your slides again, which were very good and very, very all-encompassing. And I want to thank you for that. And I will once again suggest to the person, the visitor now, that you do go back to the agent, and then when the agent will get with John or one of his cohorts and talk about all of these details, and you can be darn sure that you'll be very well protected. Don't hold me to that now and sue me, please, but you will, about as good as you can possibly get. So, John, I want to thank you again for your time and effort and sharing all this with us.